SJC-13638, Commonwealth v. Robin B. Adams.
Attorney Faulkner.
Good morning. May it please the court, this is a case where the defense presented evidence in support of two defenses. The animal cruelty statute requires a finding that there be no justifiable cause, and that comes straight out of Commonwealth versus Zaleski and Commonwealth versus Lufkin, I'm sorry. And in this case, there was presented a request for jury instructions that were consistent with the defense evidence that was presented. Those were defense of another animal and bona fide discipline of the animal. The defendant testified in his own defense that that was his purpose. There was also evidence from other sources that corroborated that. So for instance, the three witnesses, fact witnesses for the Commonwealth, testified that the defendant was punching his dog repeatedly, but the defendant testified that he was not punching the dog with force. He testified that he was using what he had been trained to do in martial arts, which is light or point contact.
Counsel, could I go back to your first stated reason? So the two bases that you gave, or at least that was presented to the trial judge, let's start first with the defense of another animal. Do you need case law that says you can come to the aid of a wild, undomesticated animal?
Well, there isn't a case that says that in the Commonwealth.
So what would be the basis to say I should be able to adduce expert testimony on a theory that has never been, at least as far as I could find, any authority in Massachusetts or really anywhere, to say that that's a reasonable basis to say the jury should be given evidence in terms of an expert on that?
Well, first of all, the expert testimony didn't only go to that defense.
Sure, but I'm asking you to, I'm going to that particular prong of the defense.
So in terms of the defense of another, the Commonwealth points out that there are 3 states that do build in defense of another animal into their case law without regard to any specific animal. The Massachusetts statute simply talks about justification, and the question is whether that's a common law defense. It hasn't been raised. It has also not been found to be an incorrect defense. And I think when we look at the case law around defense of another person, self-defense, these are justifications that deal with competing harms. And here, if the competing harm is to prevent a wild animal from being killed using some amount of force, no more than necessary, of course, and that's what was requested in that jury instruction.
But that's at the end of trial, right? So we're talking, I'm assuming you agree that we're talking about an abuse of discretion standard on the trial judge either giving it or not giving it.
Well, I don't agree. It depends in terms of a jury instruction, if any view of the evidence supports the instruction and the instruction is correct as a matter of law, then it must be given. That's not an abuse of discretion standard. That would be a de novo standard on this court.
Well, there's a lot of ifs in that. So I guess going back, the evidence, at least that in the light most favorable to the Commonwealth, suggests that they did not find any blood on Bodie to support at least the testimony or the view of your client that there was this kind of bloody back and forth such that he had to intervene on behalf of whatever the animal was. Does that play into the judge's discretion in whether or not the evidence fits to give that kind of an instruction?
No, Your Honor, and the reason is because the evidence is not viewed in the light most favorable to the Commonwealth when we're dealing with jury instructions. It's viewed in the light most favorable to the defendant.
But isn't the jury instruction that you got broader than the one you're requesting? Any justification is enough. So what are you accomplishing by sort of putting in these particularities when you can rely on anything your client was doing that was justified is enough?
Well, that's the argument that the Commonwealth makes, and I think the problem with that argument is the jury is left entirely unguided with respect to what is an adequate justification under the law. So,
But I assume, in closing, you're saying he was justified in protecting his, or I can't remember, we're protecting the hedgehog or we're protecting your dog, but he's justified in how he behaves here, right?
right, so that's the closing argument, but the problem is that the jury is never instructed that if they believe that that's true, that that is an adequate justification under the law. The jury's just left to decide whether they believe that it's justified, and that's not really the standard that the jury is to be implying. If there is a justification under the law, the jury needs to be given that so that they can determine whether the defendant has met that justification or not simply whether they believe that that's justification or not.
Counsel, going back to viewing the evidence as you suggested in the light most favorable to the defendant, can you explain why this particular instruction, and I'm still focused on the defense of an animal instruction, was warranted if it even were available at law, where, if I'm not misunderstanding the testimony, the defendant himself testified that he had already separated his dog from the groundhog at the time he was doing the disputed strikes?
Well, he had separated the dog, but the dog also had gotten away from him and was trying to get away from him and get back to the groundhog. And I think that also goes back, and this is where I think both of these two issues do interplay with each other, is it also goes back to the issue of the expert testimony. So the defense was deprived of the testimony that this is a dog that had a high prey drive. And had the jury been given that additional evidence that the dog is a high prey drive, that is something that would have also supported it. And if we look through the expert report, Ms. Puff talks about the tunnel vision that the dog has, that a dog with a high prey drive has, and that it takes something more to snap the dog out of it. And that's why simply separating.
How does a vet tech know anything about a high prey drive? That sounds like something required for a scientist or at least a veterinarian. I mean, she helps take care of dogs when they arrive at the vet. She doesn't know anything about their prey drives.
Well, she has training and experience, though, in giving these safer behavioral assessments, and she has done those behavioral assessments. And we're talking about determining which dogs get rehomed.
A prey drive is right. A prey drive is something that requires background knowledge, right? It's not just whether the dog is jumpy at the vet, right? I mean.
Correct, but veterinarians and a vet tech who is working in a veterinarian's office have to determine which animals can be in which room together. They have to make those kinds of judgments all the time. So she's doing behavioral assessments in terms of which animals can go to which homes, and has been doing that for a very long time, but is also dealing with animals on a day-to-day basis in a clinical setting where there are multiple animals, and they have to deal with these kinds of issues.
Counsel, help me on the report. Did she outline specific experience with this breed of dog?
She did not specifically talk about experience with this particular breed of dog.
So let me stop you there. So isn't one of the factors under Dobert-Lanigan that you can apply it to the facts and circumstances here? So even if the trial judge credited that perhaps she did these behavioral things in general, would that necessarily inform whether or not whatever she had to say would be helpful about this breed of dog?
Well, I think that would go to the weight of the evidence.
That's not an admissibility factor?
I think that is beyond an admissibility factor, because if she's to the point where she can make a determination about the different behaviors of various animals, the jury can determine whether they believe that in this case. But I think the key question as to the gatekeeper function is simply whether she has the experience to do it at all. And I would suggest that it's not just the trial judge, I think, talks about how she doesn't have the education to make these determinations, but the expert testimony cases in this court go well beyond simply education and clearly recognize that training and experience are significant factors and can lead to the admissibility of evidence. That a core category of expertise that's based on training and experience is, of course, police officer expert testimony, which is regularly admitted within the Commonwealth. And so this is somebody who has, again, a long history of both assessing injuries, determining and triaging injuries, and also performing behavioral assessment. So I think that goes to both prongs of the expert. And I would just add that even if one prong of the expertise was determined to be excluded, that doesn't mean that the other one needs to as well. And so even if this court determined that it was proper to exclude the evidence as to the prey drive, it's still important that her testimony as to the pain response. And the Commonwealth in the trial court kept characterizing that as pain tolerance, and that's not at all what was being proffered. It was pain response. And the reason that that was an important piece of testimony in the trial court is because what the expert opinion was seeking to demonstrate to the court is not that the dog was necessarily in any more or less pain than any other dog, but because the dog had demonstrated a pain response with regard to one area of its body, that means that that's the kind of dog that you can elicit a pain response from. Doesn't have anything to do with necessarily whether the dog's feeling the pain, but the dog, is, when it's examined by the veterinarian, who also did testify.
But I'm confused. So the veterinarian gives very favorable testimony to your client, saying there's just no injuries, no apparent injuries to the head, which is where your client was supposedly pounding the dog.
Right.
So if there are no injuries there, what's the value of the pain response point? It doesn't enhance anything, right?
Well, I disagree because it's simply because there aren't, there's no brain injuries. She does a neurological inquiry.
There's no bruising, no
swelling,
swelling, nothing. I mean, that supports your client's, the jury clearly didn't find that compelling, but it supports your client's view that he did just what he said, which is that sort of abbreviated punch that he's talking about.
Right, but a jury could find that even though there weren't injuries, the dog was in pain. And I think...
Can I ask you about the, it seems like your client is trying to have its cake and eat it, and maybe these are jury issues, but it goes to prejudice as an overall. So we basically have a scenario where he says he has to make these heroic steps to save the groundhog even after the groundhog is away. So he has to discipline the dog, and then he says, well, I had to discipline the dog, and it has a high prey drive, so I have to really, like any self-defense, use necessary force. But I just pull my punches because I'm a karate guy. It seems like there's a prejudice issue that these thoughts are contradictory. And it seems that although you may be right, there's a lack of prejudice because of that contradiction.
I'm not sure that's right because I'm not sure that there is quite the inherent contradiction that Your Honor suggests. And at any rate, I think that is something for the jury to determine. But he testifies that what he's trying to do with these is snap the dog out of it to get his attention. And that is a way that he's learned that the dog will respond to that. So he's doing that to elicit the response. And it's consistent with the veterinary testimony. His testimony about pulling the punches is more consistent with the veterinary evidence, obviously, than the witness testimony, because they testify that he's hitting the dog with force up to 10 times. And there's no evidence, even though both the veterinarian and the vet tech testify that there would be both physical injuries and neurological injuries, there's nothing of the sort. So that leaves the jury, again, simply in determining whether the dog may have been in pain. And that, I think, goes back to, again, the pain response testimony, which would have been necessary and appropriate and supportive of the defense.
Are you So you're basically saying, correct me if I'm wrong, that if the jury instruction had been given that its amount of force that's necessary, that fits the bill?
I think that that would have assisted the defense. It was consistent with the law, and that denying the jury that jury instruction deprived the defendant of his defense.
So just justifiable doesn't do what that jury instruction would give?
Excuse me?
Just saying justifiable doesn't give the flavor of self-defense, essentially.
Correct, because it's just an open-ended justifiable where the jury is just weighing whether they think it was an appropriate action or not, as opposed to whether the law protects that kind of action.
Do you think that the jury's verdict necessarily indicates that they did not credit your client's testimony about pulling back on the punches?
It certainly is possible.
What other explanation could there be for the verdict? Isn't that necessarily an embedded factual determination in this verdict?
So I think that the jury doesn't have to necessarily discredit that. If the jury finds, again, and I would liken it to assault and battery case law. You don't have to prove injuries for an assault and battery. Any amount of pain is enough. If it's a harmful contact, we have serious bodily injury enhancers for it, right? So if the jury finds that there's some pain that comes with this contact, that might have been enough for them to determine that that's appropriate to the verdict. And again, I think that's where being given the justifications, particularized justifications, it might have made a difference in the case.
Okay,
No further questions?
thank you. Okay, Attorney Cohen?
Good morning. May it please the court, Jennifer Cullen for the Commonwealth. The Commonwealth argues that the instruction as given at the trial was adequate, and in fact, the instruction as to justification or the definition of animal cruelty is so broad and is very favorable to the defendant as it is. While there may be some reason for elaborating on.
How do we know it's so broad? I mean, when we incorporate all these sort of standard instructions, it provides definition, but how does the jury know what's justifiable here without sort of further clarification?
I mean, I think the way that this is worded is any justification, and I think that the defendant also raised the defenses that he's now.
It's a complete defense, correct?
Yes, Your Honor.
All right, if this was a person case.
Yeah.
And the judge didn't instruct on assault, on self-defense, would you be standing here or would you just concede error?
Well, I think that even if an instruction.
I think the answer is probably yes, correct?
Potentially, yes. But I do think that in these particular circumstances, even if this court were to decide that the instruction should have been given and it was error not to give it, I would still argue that there was no prejudice to the defendant, given that the definition of cruelty was read 3 times. The jury was instructed very thoroughly on the fact that this was
Before you move to prejudice, though, I just want to, because this is sort of a Pandora's box. Are we going to have adjutant evidence here? Are we going to? I mean, how far are we going to go with all of this? Are we going to incorporate all of the people defenses and subtleties to it?
Sure, and Your Honor, that's why the Commonwealth is also arguing that this is a determination that's better left to the legislature. I think that the legislature has demonstrated an interest in the area of animal cruelty. The recent task force provided recommendations which pretty much exclusively pertained to education as a recommendation.
But do we need to provide some more clarity about what justification means, or is it self-explanatory?
I think it's left to the jury to decide what a justification is. I would argue that allowing these kinds of defenses to be raised in animal cruelty cases raise questions of public policy that I'm not sure Massachusetts is interested in promoting.
Well, I guess if there were a reason for the clarity, I certainly think this is one case that highlights that. I mean, are we going to? I mean, if it were another domestic, if they were at a dog park and it was another domesticated dog that the Bodie took after, I don't think there would be much in debate that, yeah, you've got to stop that, right? I mean, you've got to intervene. And if we're talking about a wild animal, I don't know that that's necessarily in the same neighborhood. And wouldn't that have been something that could have been the clarity that perhaps the justification needed?
Sure, and I think, though, Your Honor's raising of these kind of hypotheticals is kind of part of the problem here. I agree that if we were talking about a fight between two dogs, that an instruction on bona fide discipline or defense of another may have been more warranted. But I think once you start looking at, I guess the instruction that my brother is requesting is defense of a wild animal. And I think...
Well, he's requesting two.
Sure. I guess defense of, but the instruction on defense of another animal is defense of basically any animal. It's not.
But is
just,
the animal cruelty statute limited to, doesn't it extend to all animals?
It does, Your Honor, but I think this instruction as requested leaves us in a situation where a person can punch a bird and then claim that they were defending a worm from being eaten. I think this instruction could potentially apply to all sorts of circumstances that I'm not sure that the Commonwealth would want the defense to be applicable. I think
What about the bona fide discipline instruction? Why wouldn't that be appropriate? I see why the wild animal versus domesticated animal defense might require a policy decision, but what about the bona fide discipline?
So I think comparing this to the parental discipline instruction, the three prongs that the Commonwealth must disprove beyond a reasonable doubt probably could be translated into the area of animal cruelty. However, there are two paragraphs that follow that outline the factors that the jury should consider when deciding whether force used is reasonable or reasonable in the circumstances. And I'm not sure that those paragraphs necessarily translate to the world of animals. I'm not sure that, and I think once an instruction is given using those sorts of factors, that puts something in the jury's head that I'm not sure should be there. I think, it's talking about the age of the child. It's
So you're fine with the three-pronged Dorville test?
I think that potentially...
But not the subsequent instructions that follow, the two paragraphs?
Yes, and I think that perhaps elaborating on the instruction, at least of defense of another animal, could be more protective of victims of animal cruelty.
But sticking with the bona fide discipline, your position is that the adoption of the Dorville three-pronged standard without the subsequent paragraphs would be permissible?
I think that that would also be better left to the legislature.
Why?
Because I think those factors of reasonability in the context of animal cruelty need to be looked into further. I think that...
Well, isn't that what the Zaleski and the Lufkin cases already provide?
Sure.
So it seems to be part of our law already, and the three factors, of the three factors, do any of those not really codify the Lufkin standard?
So I think the other point, Your Honor, is that is a case from the 1800s, and it
Right, but
pertains to
Zaleski
horses.
is 2009, and granted, it's the appeals court, not the SJC, but still, it's binding law.
And I think the instruction given there was fairly perfunctory, and that bona fide discipline is a defense was the only instruction that was given. So I would agree that is a defense. I would just say that the instruction as written now adequately covers any justification whatsoever, and to elaborate further and to create parameters that a jury is now going to be considering is something that should be left to the legislature because of those various factors later on. We need to decide whether bona fide discipline, if that instruction can apply to any animal that a person might own. Does that apply to a horse, a snake, a dog?
Well, Lufkin was a horse.
Sure.
Yeah.
Yeah. But again, the only instruction given is that bona fide discipline is a defense.
But that was given here?
in Lufkin.
I know, but was that given in this case?
No, any justification for
Okay, and the instruction that was requested was,
akin to Lufkin.
okay, and that was not given?
That was not given. And I would also note, Your Honor, that at this stage, it does appear that my brother is asking for an instruction more akin to parental discipline.
Right, but
don't think that-
your fallback is that the requested instruction, which doesn't have the Dorval three factors, would have been proper.
I think it is a defense. I think that it was within the judge's discretion to provide or not provide that instruction. I think the instruction given adequately addressed any justification.
And how would the judge exercise that discretion? What are the factors that the judge would need to determine in determining whether to give a Lufkin-like instruction that was requested here?
Well, I think here, looking at the evidence in the light most favorable to the defendant,
Yes.
I would argue that the defenses weren't raised. I would argue that even the defendant's testimony wasn't supportive of either of the defenses.
It wasn't supportive of bona fide discipline. I mean, he's walking away from the dog, saying, the dog will follow. It turns out the dog has this high prey instinct, apparently, and won't listen. And so then he captures the dog and pretends to punch him.
Sure, and if Your Honor disagrees with that position, I do think nonetheless.
But no,
that
I'm applying the test that you've articulated. Viewing the facts in the light most favorable to the defendant, he was raising a bona fide discipline defense. Wouldn't you agree?
I would argue that he perhaps raised bona fide discipline. I don't think that he raised defense of another.
Okay.
But then I would say that even in those circumstances, there was no prejudice to him given the fact that the definition of cruelty was read multiple times.
Wasn't it read multiple times, as I recall, because the jury repeatedly asked?
Yes.
Doesn't that indicate some question on the jury's part about what the law that they were supposed to apply was?
Sure, and I think the way that the instruction is written, I would concede that it is a bit confusing that the definition of animal cruelty comes so late in the instruction. I think that if that were given at the outset, as it appears to apply to the entirety of the instruction, that would perhaps be a better way to instruct the jury. But I do think that part of what the foreperson said was something to the effect of, can you give us the definition of what we're looking for? I think it was clear that that applied to the entirety of the instruction. That was what they were looking for. They knew that it was the Commonwealth's burden to prove that there was animal cruelty beyond a reasonable doubt. And so,
Counsel, if you take those two things, though, it really then dovetails into the issue about the expert. Because if they have all these questions about what animal cruelty is, and he is raising a bona fide discipline defense, what I'm struggling with in this case is it did not, at least the evaluation of his potential expert testimony. So if we know one of the reasons why we allow expert testimony is it's helpful to the jury, and they have all of these questions, wouldn't it have been helpful to the jury to hear from this expert? Whatever weight they wanted to give to it was one thing, but because it helps inform the animal cruelty and the bona fide discipline defense. If they hear, hey, this dog has no off button once he gets kind of in a lather, and the Commonwealth didn't raise a motion in limine. It happened midstream. The witness was on the witness stand. How do we use all of that in engaging the abuse of discretion here, because the defendant was left kind of flat-footed?
Respectfully, I disagree, Your Honor. I do think that it would have been better if the issue had been raised in the motion in limine phase, or if a voir dire had been conducted of the expert. Nonetheless, I think the testimony that was given by the Ms. Puff and her CV didn't indicate in any way that she would be qualified to testify to pain response or neurology or animal behavior. I do think that she mentioned that the safer assessments. I think that's in her report, but when you look back at her CV, it's clear that she was conducting those assessments in 2013 and 2014. So I do agree it would have been better to address this more fully out of the earshot of the jury. But I do think given the fact that her testimony what she was going to testify didn't seem to come within the purview of her actual expertise or her day-to-day work. I think it was in the judge's discretion to exclude her testimony as an expert on those specific points. But even if the court disagrees with that, I do think that exclusion of the testimony here is harmless beyond a reasonable doubt, because the testimony about pain response essentially would have been cumulative to what the veterinarian testified, where she testified that the only pain that the dog seemed to be feeling was in its foot. There were no other physical injuries to the dog. And I think she also testified that it would be very unlikely for any injuries to appear more than 24 hours after an incident. So I think as far as pain response goes, that was extremely favorable evidence for the defendant and essentially covered that portion of Ms. Puff's testimony. And I think as far as the prey drive, I would still say that the Commonwealth witnesses were all consistent in the fact that the dog wasn't listening, was fixated on something. It was clearly being disobedient. I think the Commonwealth's testimony was consistent with the defendant's theory there. And so again, I think that where Ms. Puff wasn't allowed to testify as an expert, the defendant wasn't losing out on that as a defense.
The one thing, so the definition of cruelty, it's severe or unnecessary, right? It helps clarify the meaning of justifiable cause, but I take it the argument is you don't know how much pain you need to inflict to shut the dog down. And by excluding the prey drive and this other stuff, the jury has a difficult call if it credited the defendant, right? It's a tough. How much is enough to shut the dog down?
I would disagree, and I would say that even fake punching a dog would be a very unreasonable action.
Really, if he was telling the truth, and these fake punches would shut the dog down without hurting the dog, isn't that a good defense? I mean. He gets himself into a problem when he talks about all the blood on the different animals and there's no blood anywhere. But if it's true and he's punching the dog without touching the dog, that seems pretty good, right?
I think using a scare tactic to discipline something is unreasonable. I think we would not be supportive of that if it were a child.
I know, but a dog's not a child.
No, it's not, but it's the living thing. And I think that fake punching as a scare tactic is not a reasonable way of disciplining an animal, especially where he could have easily just used his hand to put the dog on a leash instead of fake punching it.
Isn't that a classic jury question, whether it is or not is not reasonable to discipline your dog by fake punching it?
And I think where the jury were instructed that there could be any justification for this defendant's actions, I would agree with Justice Wallahogian earlier stating that I think that the jury did not credit the defendant's testimony. I think that was what was found in their verdict. I don't think they credited that this was fake punching. And I think even if they did think it was fake punching, it was a question for the jury, but I think they didn't credit the defendant here.